Hello, everyone, and welcome to the Alberta Council of Women's Shelters Legal Matters Podcast. Today, we're going to be talking about recent changes to the Divorce Act, and we're very fortunate to have a couple of very knowledgeable speakers with us this morning. First of all, we have Angela Rooks-Trotzuk, who is the CEO of the Lloydminster Interval Home Society. This society is an ever-evolving and passionate organization which is dedicated to developing lifetimes of well-being and healthy relationships for all. Angela provides leadership in crisis response and support, psychosocial education, advocacy, strategic organizational change, and community development. And through these roles, she has worked to support and advocate for women and children impacted by the devastating results of violence for over 20 years. Her current work is focused on organizational and community development in response to gender-based violence to ensure that communities are educated, equipped, and responsive to the impacts of violence. We also have today Sandy Vander, who is a partner at Dunphy Best Blocksom LLP in Calgary and specializes in family law. She is a registered collaborative family law lawyer, a mediator and arbitrator, as well as a dispute resolution officer at the Court of Queen's Bench. She has been in the practice of law for 21 years. In her spare time, Sandy is passionate about her community work and particularly her work in the area of family violence. In the community, she is on the board of the Canadian Women's Foundation and the board of the Alberta Council of Women's Shelters. In her role with the ACWS, Sandy chairs the Social, Legal, and Ethics Committee, although she says her greatest accomplishment is being a mom and wife. And I should introduce myself as well. My name is Jennifer Koshan. I'm a professor in the Faculty of Law at the University of Calgary. I did a brief stint working at the same law firm as Sandy, and then worked for several years as a Crown prosecutor in the Northwest Territories, following that as the legal director at West Coast Leaf, which is a women's equality rights organization in Vancouver. And since the year 2000, I've been at the University of Calgary Law School, so that's for over 20 years now. And my research focuses on human rights, equality law, and gender-based violence. So, as noted, what we're going to be doing today is talking about some of the recent changes to the Divorce Act and specifically about how family violence is now included in the Divorce Act. So, Sandy, I wonder if you could get us started just speaking to some of the key amendments to the Divorce Act that came into effect this past year.
Yeah, I think that it's really important to note that the amendments that came into effect are things that, as council, we have always been alive to, but they're legislated now, and so there's a number of amendments, but for the purposes of this discussion, one of the ones that's really important is the notion of the removal of the words custody and access, and repealing those terms and replacing them with terms such as parenting time, parenting responsibility, really looking at more collaborative language around family law, which is something that I think a lot of council will agree we've been trying to move away from. And in addition to that is the only focus in parenting has always been the best interest of the children, but it's now in there and it's legislated, and so that's a primary focus that the courts and decision makers need to look at. But in terms of family violence, the really important, and I think, I don't know if I want to say groundbreaking, but the critical change was the fact that family violence is now in there as well, and it's listed in terms of, it's not an exhaustive list, but there's a number of examples of what family violence would be. And I think that's really important because it's also allowed the discussion in terms of family violence isn't just something that is happening to one person. It can be exposure to family violence for a child, and how does that impact a child in terms of trauma informed responses and trauma informed programming, and that's on a whole other level, right? But that's one of the things that I think is really important, and more importantly, it doesn't require a finding of guilt in the criminal context. And I think that's really important.
So I can say from my discussions with my colleagues and clients that the changes are welcome changes that have come into effect.
Thanks very much for that, Sandy. And I guess maybe something I would add, just from the perspective of a legal researcher in the area of gender-based violence, is that one of the things that really impressed me with the changes to the Divorce Act is how broadly family violence is defined in the legislation. So it includes not only physical and sexual violence, but also emotional abuse, psychological abuse, financial abuse, coercive controlling violence, and really the only other jurisdiction in Canada that has defined family violence that broadly so far is BC in its family legislation. So something I'm really interested in following going forward is whether Alberta will also be amending its family legislation to align with the Federal Divorce Act. Some provinces have done that already: Ontario, Saskatchewan, New Brunswick, PEI. And I'm really hoping that we can put the pressure on the Alberta government to amend our family law legislation to come into alignment with the Divorce Act as well.
Yeah,
but
I
maybe
think it'll
now,
be
Angela,
critical to do that. Sorry, I didn't mean to interrupt. Yeah, I agree. I think it'll be critical to do that so that there's consistency across the board.
right, and maybe just so our listeners are aware, the significance of Alberta's Family Law Act is that it applies to parties who are not seeking a divorce or who were never married. So in my view, it's quite a problem if we have different definitions of family violence applying to families depending on whether they were married or not. And in Alberta, under our legislation currently, family violence is defined much more narrowly, so that it focuses on physical and sexual violence and doesn't include emotional or financial abuse. So that seems like a gap that we need to fix here in Alberta. But Angela, maybe I'll turn it over to you now to talk a little bit about what impact you think these changes have, or what impact you hope they'll have from the perspective of your clients.
Yeah, I mean, we are pleased to see that domestic violence is in the legislation now. So we have a lever to pull. And like you guys talked about, the definition is quite broad, and it's inclusive of indirect and direct violence, as you mentioned. And again, no criminal code offense kind of needed to be recognized in that. So although this is all theoretical, from our experience at this point, for the women that we work with, we're excited to see some of the practical changes and the practical implications that will come from this legislation. We currently haven't seen, I mean, it's quite new. I think it was March 1st, if I'm not if I'm not mistaken, that it came into effect. So we haven't seen any practical implications at this point, but that's what we're really looking to see, as well as a recognition from legal counsel that it's an important piece of the puzzle that needs to be really understood and really taken seriously, especially its impact on children, whether that be a direct experience of family violence or abuse or an indirect experience of abuse, because that's where we see things really fall apart, is that understanding of the impact of indirect exposure to violence for children in particular.
Thanks for that, Angela. And one other change to the Act that we haven't mentioned so far, Sandy mentioned the best interests of the child being the primary consideration for making parenting orders under the Act. But something I think that's also really important is that the primary consideration when we're thinking about the best interests of the child is supposed to now be the safety and security and well-being of the child. So if we put all of that together, the broad definition of family violence, best interests of the child, safety and security of the child, it seems that these changes really should make a difference to how these cases are being resolved. Sandy, go ahead. Sorry, Angela.
No, that's fine. I was just going to say too, and some of what we see in our work is what used to be, if I'm not mistaken, the assumption that each parent should get maximum time, and really the best interest of the child was really not fully considered, I would say, in our experience in relation to domestic violence. So we're eager to kind of see that piece that I think has been divorced from the assumption, and be able to look at truly what is the best interest of the child.
That's great. Thank you. And Sandy, maybe you can comment on how these changes are starting to influence the kind of work that you're doing. So, mostly you do mediation and collaborative law. What sorts of changes to your practice and your work with your colleagues do you think these changes to the Divorce Act are creating?
Yeah, it's a really good question because the changes, as we've discussed, only came into place on March 1st. And so there's been a lot of education and awareness around the changes and how is that going to impact the practice of family law, because there's changes as it relates to relocation as well. But for the purposes of this discussion, I think it's too soon to tell with respect to obviously precedent in case law, because I'm not in the courts. I don't do litigation, so I can't speak to that specifically. But in terms of my own practice, we're having I've always had these discussions with my clients because this is something I've been passionate about for a long time. So what it's doing is it's allowing me to talk to my colleagues because they have questions for me. What is family violence? How do I address that with my client? How do I have that conversation? And also, and not that they haven't had the conversation before, but feeling that they're going to have a more in-depth conversation to really understand the nature of the issue. What training is out there? I know that right now there's training being put together in terms of family violence for counsel, and I've been participating in kind of a group that's reviewing the materials that the government's putting together, Justice Canada's putting together. And so I think that there's still a lot of discussions that are happening, which are bringing the issue more to light than it has been before. And I think that's really important. And I think it's also important because it's allowing the dialogue to happen in terms of looking at the definition of family violence and then looking at the impact of the indirect exposure for children, and for courts to really start thinking about what that indirect exposure is doing to the child when they are considering the only thing they should consider under the law, which is what is in the best interest of the children or child. So I think it's a dialogue that needed to happen from my perspective anyway, and it's a welcome dialogue. I think that there are a lot of counsel out there that really want to make sure they're having the right conversation and the appropriate conversation. And some have even approached me and said they want to make sure when they're having the conversation that they're not triggering the client. And so I think it's also opening up an opportunity for counsel to collaborate with people like Angela in the community and in the sector, so we can have those discussions and make sure that we're doing our job the way that we need to do, but in doing our job that we're not unnecessarily further impacting the client on their journey in terms of what they've been dealing with from a family violence perspective. So I know it's a bit of a longer answer, but I think it's about the response, the dialogue, and then the opportunity from my perspective.
Thanks, Sandy. So important to be thinking about taking a trauma-informed approach to dealing with these kinds of cases. Angela, do you have thoughts on that kind of work and the possibilities for collaboration between organizations like yours and lawyers who are providing legal services in these cases?
Absolutely. I think we are waiting for that opportunity. I think sometimes people are afraid. I mean, there's the real fear of domestic violence and family violence in families and becoming involved in supporting that process. But also there's the sheer, what I sense from folks is the overwhelming, like, this is a big, complex issue, and this is not my wheelhouse, and I'm not sure where to start. And that's where places like the Lloydminster Interval Home Society and so many other organizations across the province, this is our work. This is what we do every day. This is our expertise. This is our knowledge. We can help. And sometimes it does feel, when we go out into communities, there's not a resistance because people don't care. There's a resistance because it's a complex issue and people don't understand it and they're not sure where to start. So I think there's such great opportunity for organizations such as, ACWS and all of the individual shelters across the province that have the capacity to come alongside and help educate and support and build that capacity in communities to really make a difference for families that are impacted by this, and both sides of that equation, right? The partners and the perpetrators and the partners. And I don't know if I like that language, but I've used it now. But there's really an opportunity to really go to work in solving this issue.
That's great to hear, Angela. Thank you for that. And I mean, something else that makes me think about is the need for judicial education. And earlier, Sandy, you mentioned that there's been a lot of training for lawyers that's happening at the current moment, and that's great to see. My understanding is that there's also been some judicial education on what the changes to the Divorce Act mean for judges who are going to be hearing and resolving these disputes, for those that actually do end up going to court. And I think, even cases that don't end up going to court, we still look to those judicial decisions to say, well, this is kind of the framework or the starting point for how those disputes are going to be resolved. And something I'm wondering about, I think it's fair to say that there's been some concerns with the way that courts have handled family law cases involving family violence prior to these changes to the Divorce Act. Angela earlier mentioned almost a presumption that was read in about maximum contact, the idea that it was in the best interest of the child to have as much contact with both parents as possible, even if one of those parents had committed family violence against the other parent. And I wonder whether we should be thinking about not just judicial education, but also the possibility of getting some of the expertise that shelter organizations have in front of judges. So getting expert evidence before judges to say, here's what the significance of these changes in the Divorce Act is, and here's what the context is for the dispute that you're hearing. And maybe that could be helpful in really getting judges to take a different view of these kinds of cases.
Yeah, I think that, in my work with the ACWS and chairing the Social, Legal, and Ethics Committee, that's one of the things that we're talking about is approaching the judiciary and talking to them about these changes, not just from a legal perspective, but bringing in the experts in the sector so that they can at least have the conversation and they can understand the impact from a legal perspective, but also from the sector's perspective, which is equally, if not more so important, I would say. And so we're working on that and committed to having those discussions, because I think they're imperative to being able to understand that we have the intention of the legislation, but then we need to make sure that that's put into practice.
Any thoughts on that from your perspective, Angela?
Yeah, I mean, the more people we can get in front of that have the opportunity to make these, in a lot of cases, life-altering decisions for folks, that this whole piece of into people's lives is not being considered really fully and completely. And the more opportunity we have to bring our expertise and share that, and share the facts, share the data, share the research, I think just the opportunity that makes to, or that brings to make positive impact for people is what we do. Like, that's our work, right? And that's exciting. And I think the other avenue that we do need to consider is the gender nature of family violence as well, and how that plays into some of the assumptions that people will have. And I think that element also needs to be realized. The stats are roughly 8 in 10 instances, it's male perpetrated on female violence, right? So I think the whole gendered lens of this as well needs to play into that. And I don't know if you do that all at once. I think that's the best way to do that, but that's also an element of the education I do think that needs to go out as well.
So one thing that I have seen in my research is that I think judges have gotten better at handling myths and stereotypes in sexual assault cases. Not to say they're always getting it 100% of the time, but I think there's been some real progress there. And I fear that we haven't made the same sort of progress in domestic violence cases that end up going to court. So for example, right now, a lot of people are talking about how when women, and it typically is women who are raising allegations of domestic violence in family law cases, make those allegations, they are sometimes hit in return with allegations of parental alienation. And I'm wondering if you two have any comments on that from your perspectives.
Yeah, I mean, I do, Sandy. I can go ahead if you don't mind. That is probably one of the most frustrating pieces for us that our clients see is there's legitimate claims of family violence made. And unless there is a piece of criminal, or unless there's a criminal offense to kind of go along with that allegation, we find that it can be easy to write it off as manipulation, i.e. parental alienation. And it is incredibly frustrating from the client perspective, and also extremely demoralizing, but also risky to the children that are exposed either indirectly or directly to family violence. So I can only hope as a service provider that having the definitions embedded right in the legislation and the recognition of indirect and direct terminology and explanation that, and I mean, if we can layer in the gendered understanding of domestic violence as well, I hope that those kind of those biases, those myths start to deteriorate as well. But yeah, that's a very negative practical implication for clients that we see right now.
What about from your perspective, Sandy?
Yeah, I think it's really interesting because, I mean, I come at this from a professional perspective, but then I've also been involved in community work around family violence for, coming on 15 years now. And so it's hard because I see the realities of what's happening at the shelter level and in the sector. And then I see it from a legal perspective as well. And I think that the intention of the change under the Divorce Act was to finally talk about family violence and to finally, not that the list is exhaustive because we've already talked about that, but to have the triers of fact really think about that the impact that that's having on a child. And so my hope is that that perspective on alienation, and that being a driving factor, will be something that people will really question and see and look behind it to see what's happening. And there are ways for that information to come to light that just doesn't have to be through affidavit evidence that's between, party A and party B. There's professionals that parties can go to and to get to the bottom of what's happening and to provide that information to the trier of fact so that they can confirm for themselves what is happening in the family and how is that impacting the children. Because at the end of the day, as we've discussed throughout this, the best interest of the child is the primary consideration. And so you have to look at all of the factors to get to what does that best interest look like.
Thanks very much for that, both of you. From a legal perspective, and someone who does research rather than being directly involved in a practice way with these issues, one thing that really jumped out at me from the new legislation is that the Act is very clear that there's no presumption one way or the other in favor of a particular parenting arrangement. So for example, shared parenting or joint parenting arrangements aren't necessarily presumed to be in the best interests of the child. And also one of the things that judges are required to consider is whether family violence has an impact on the extent to which parties are able to cooperate when it comes to doing things like arranging contact visits for the child. So I'm hopeful that if lawyers can get into court and really emphasize those differences in the legislation compared to the way things were before, that courts will realize that it was the intent of Parliament to make some significant changes to how these disputes have been resolved, and we will see these differences happening in practice. But I think we do need to get that training for judges in place, as well as some expert evidence before the courts as well. Now, Sandy, you do a lot of work outside the courts in collaborative law, in alternative dispute resolution, and I think one of the other interesting changes in the Act is that lawyers are supposed to be encouraging their clients to try to resolve their disputes in a way that doesn't require going to court. The parties themselves are also supposed to be using their best efforts to resolve their disputes without using the mechanisms of litigation. So have you started to see any changes in practice in that area as of yet, or where do you see that going for alternative dispute resolution?
Yeah, it's interesting timing because we started to see a real shift, at least I started to see a shift in people exploring alternative dispute resolution, or ADR as we call it, with COVID, because of the impact and the challenges that the courts were having with delivering justice because of the fact they couldn't have people in the building as they traditionally did. And so we started to see a real shift in the focus on ADR because people were looking to get decisions and they were looking to get them quickly. But also I think that it wasn't just about that. I think that when you had COVID and then you had that combined with the changes to the Divorce Act and also people knowing that the changes were coming into place because they were going to come into place sooner, and then COVID put that off again. And so March 1st is when it came into place. And so I've seen a tremendous shift in my practice anyway, where people are saying, I appreciate that I'm not necessarily going about it the right way in terms of what they want for their families, and so they're exploring ADR as an alternative. And one of the things that the Divorce Act talked about is alternative dispute resolution, and that the lawyers and counsel have the obligation to talk about that and promote the goal of avoiding litigation. Because from my perspective, and I did litigation for a long time before I moved into ADR, I moved into ADR because I found that it was a different focus for families, and families were able to go into that process, and they were able to have creative control over what their resolution was going to look like. And it's not a disparaging comment against the courts, because the courts are doing the best with what they have. But we talk to clients about, here are all the options available to you, and here are the pros and cons of each option. And I think when you look at collaborative, or you look at mediation or arbitration, there's just there's a focus that can be different for the clients, and they like the fact that they are sitting in a room with a process that is allowing them to not be as formal as the courts are, and to really focus on what is best for their family, and to try and find a way to have common ground between them and the other party, so that they can get a resolution that supports the family moving forward, as opposed to the children being collateral damage in the process. So I am seeing a shift, but we've been busy for a while, and we're busy now. So I think it'll be time, probably in the next year or so, I would say we'll be able to see the real impact of the focus on ADR in the Divorce Act, and also what happens with the courts as we move through the COVID protocols and restrictions either being lifted or increased. And so I think that's a question that we'll have to reevaluate as time goes on.
Thank you for that, Sandy. It's interesting. There's some research showing that alternative dispute resolution can sometimes be helpful in cases involving family violence, because when matters go to court, court itself can become, or litigation itself can become, another way of perpetuating abuse. But at the same time, there's also research showing that ADR isn't always appropriate in cases involving family violence. If there's a real power imbalance between the parties, the lawyers may not necessarily know that there's been family violence, because my understanding is that there's still no obligation on lawyers to screen for family violence, even under the new Divorce Act changes. So Angela, I wonder if this is something that you're hearing from your clients, and if you have thoughts about this.
We have, I can say that the experience of our clients in real practical implications, in a general sense, has not been positive. And in relation to mediation and the impacts of family violence on the family unit, because there was such a vast power imbalance going into that discussion, collaboration, mediation. And I think there's room for it if the mediator is skilled and has a full scope understanding of family violence and how it shows up in the dynamic of that relationship, the nuances of family violence, the power and control dynamic. So I don't have a strong yay or nay. I haven't seen it have positive impacts for our clients in a very general sense. Of course, there has been positive mediation that clients have experienced, but I would say on there's probably more fear, negative impacts for that family or for that woman, I should say, and her experience of mediation versus it being a positive experience, strictly due to the power dynamic. And I would say probably, like I mentioned, a really full scope, nuanced understanding of family violence. So I don't think that they can't go together. I think that a mediator has to have that understanding of family violence and power and control structures and dynamics.
Thanks, Angela. And Sandy, from your perspective, do you think that that's a direction that mediation is moving towards?
Yeah, I really appreciate what Angela is saying. And I wanted to clarify, when I was speaking about ADR, I was speaking about it from a more general sense, in terms of my work. I am seeing a lot of my colleagues that do ADR and are very well respected in the area screening for family violence, and they have before. I think the screening as has now just become a little bit more involved because of the changes to the legislation, and really understanding it, and also trying to find out what do they need to know in order to effectively deliver an ADR process with those issues at play. I can say I'm very careful about whether or not whether I'm the mediator or I'm counsel in a mediation, whether or not I take a client into that process if there's been family violence. I have had a couple situations where the clients were determined to go into the ADR process with that being a significant issue, and we put into place pretty specific parameters, and we had very significant discussions about it between counsel and the mediator to make sure that there was comfort. And we also, I mean, I don't want to get too down the legal road, but we also went in on it as a mediation as opposed to a mediation arbitration, so that we could pull out, right? If those parameters weren't respected. So I think that, it's hard because I come at it with, I have a lot of knowledge because of my work in the community. And so there are people who have really good intentions, but they might not have that knowledge. And so that's what the education and the awareness piece is really working towards. And so I think it can be done if you've got people who are really alive and aware to the issues and the impact that those issues are going to have on the process, and not just the process and comfort for the client who has been the victim, but also the perpetrator, because there's and I know Jennifer and Angela from a research perspective, and also from what we know about family violence, it's a cycle, and there are reasons why people come into a relationship and these things happen, and it's a cycle that we're trying to we're really trying to work to eradicate. I mean, that's ultimately the goal of anyone in the sector, right? And I think about my work with Sunshine Community Services and the fact that we built the Children's Center, and the Children's Center was really to look at children who've been exposed to or victims of family violence, and getting them before a certain age so that you can rewire the effects of the trauma and the brain development, and ultimately change their course and change their path. And I know I'm digressing a bit, but there are lots of factors that you have to look at when you're looking at family violence. I mean, you've got someone who's been the victim, and you've got someone who is the perpetrator who may have been the victim, and in most circumstances probably was. And so it's an issue that is so complicated and so complex that it's not just about the legal issue anymore. It's about understanding where everyone comes from, that comes into the picture. And if you can have a real sensitivity to that, I think you can have a successful ADR process. But I say that with caution, because I am very careful about bringing anyone into the process who has had that kind of experience. Because you want to make sure that it's a process that's healthy, and that ultimately the goals are being met by all parties. So I know it's a bit of a longer answer, but it is a more complex and complicated discussion that has to be had to understand the impacts that it could have on families.
And I'm just thinking of, sorry to jump in, I know we're getting close to time. I think in saying that, I think there is, if we could figure out how to do it safely and properly and truly effective for both parties. Because I agree, most individuals who perpetrate abuse have experienced that as a child, in their childhood. It's a generational thing. It's a cycle thing. It happens over and over and over again till that cycle is interrupted. And I think what you're speaking about, there's real opportunity to gain empowerment from that process if done correctly and done safely. And how do we make it happen?
Yeah. And, I think about a situation I had where the husband was the perpetrator, and he recognized it. He was completely accountable for the behavior in the marriage. And the wife recognized that it came from a pattern and a history. And they were a very interesting family because they still loved each other very much, but they couldn't live together anymore. And he didn't want to live with her anymore because he knew that the impacts of the family violence were devastating her and the children, and he wanted help. And so when we went into that process and we had long discussions and put in parameters, and I had excellent counsel on the other side who worked with me, and we were able to get the family through the process and in a much safer place. And part of the discussion in the process was really getting him that help and finding the help available to him and bringing that help in. And that was in a collaborative file. And it was probably one of the ones I was most proud of, because when they walked out, sometimes when people walk out of meetings, they don't walk out together. And they walked out together and they were talking and they were laughing at the end of it. And it was just a recognition that they both came to the table with very, very similar goals, but they recognized that what was happening wasn't working, and we were able to help them put into place a family plan that worked to help him with his issues, and also how do they communicate that to the children as they move forward, because the children had seen dad as an angry person, but the children were younger. And so we also had to get a professional involved to have that conversation with the children, because she really wanted to make sure that the children understood what happened when it was appropriate and age appropriate to talk to them about it. So I do think it can be done. And I do think there's opportunities. We've talked about this, Angela, throughout this time, but I think there's opportunities to connect with the sector and really have those discussions and have I don't want to use the word collaborative, but like collaborative discussion, because I think in family law, you have to look at all of the issues and you have to understand them. Particularly when they come into your office and they need support, and that's your job.
Yeah. And I can speak, if I can be so bold to speak for the sector in its entirety, I would say that we want collaboration. We want to be able to share what we know to help individuals, help families, to help women, to help children. And if I could say, if there was one message that I could get across is, ask us, let us in. We have the knowledge, we have the expertise. This is what we do, and we want to help. And that's the bottom line, is we want to be able to educate. We want to be able to share what we know to help women, children, and families. That's really the bottom line.
That seems like a really excellent and positive note to end on. So I want to thank both of you so much for participating in this podcast today, for bringing forward the issues from the perspectives of the clients that you work with. I think the need for collaboration and the openness to collaboration is a really good way forward for all of us who are working on these issues. So I would like to thank the Alberta Council of Women's Shelters for inviting all of us to participate in this podcast today. I think it is the first of many discussions that we'll be having on these issues. And so until the next time, thanks to everyone involved.
Thank you.
Thanks so much.